Hello, 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 and thank you so much for stopping by. All right, so this week's question is, can a beneficiary override a spouse? This question is specifically related to wills and inheritance. I'm not exactly sure what the question is really trying to ask, but I think what we're being asked here is whether or not someone who's listed as a beneficiary would have priority over someone's wife or husband. And the answer to that question is it depends. So in the two states that I practice, which is the only two that I could speak for, there are rules in place that would prevent a spouse from being completely disinherited. So if we're talking about can a beneficiary override a spouse, are we talking about leaving the spouse completely out, not leaving them anything, and leaving certain beneficiaries in place in a will? If that's the case, then maybe not, because the spouse has certain rules or certain laws rather that protects him or her, and they are able to go to court and petition the court so that they can get what's called an elective share, meaning a percentage of the estate, even if they were technically left out. On the flip side, can a beneficiary override a spouse? In previous videos, I've mentioned that there are ways to avoid probate, including making things payable on death, having things transferred in trust. In those circumstances, if we don't really have a whole lot of assets going through probate, it may mean that not all of the assets are, for lack of a better word, not all of the assets are available for the spouse to get their hands on. But ultimately, if we're talking about two people who are legally married, there's not really a way for a beneficiary to kind of kick them out completely. They can and probably should inherit from the estate if they take the appropriate steps. This can be a bit complex and it's case specific, but the short answer is it depends. Sorry, that's it.